The chairman of Tantita Security Services Nigeria Limited, Government Tompolo, popularly known as Tompolo, has denied the publication issuing a 21-day ultimatum to the federal government to release the leader of the indigenous people of Biafra, Nnamdi Kanu, who is currently facing trial for treason. In a statement released by the media consultant to the surveillance company, chairman, Dr. Paul Bebenimi Bo Tompolo described the trending publication as false and misleading report authored by those who are envious of his contributions to the recent rise of Nigeria's daily oil production. The statement further reads that Tompolo has rejected the publication, describing it as a tissue of lies. He urges Nigerians to disregard the misleading information intended to arm twist the federal government against the surveillance company whose collaboration with security agencies has curbed pipeline vandalism, crude oil theft, and sundry maritime crimes. Tompolo assures the federal government, led by President Bola Tinubu, of his continued support for the renewed hope agenda, adding that he's already endorsed the president for a second term. Okay, let's have this conversation with the Director, Abuja School of Social and Political Thought and Arise analyst, Associate Professor Sam Amadi. Very warm welcome to Newsnight. Sam,
thank you, Chris.
Yeah, I think we should begin with the Nnamdi Kanu story. Under what circumstance, I mean, as a lawyer, should a person accused of such heinous crime, terrorism and, others like that, decide to defend himself without a lawyer? And what is the justification for such?
Well, it's usually unusual. It's unusual, actually, to have anybody standing trial for such very serious charges, whether proven or not in court. Those are serious charges, to have them say, I want to defend myself. But again, the Constitution guarantees everybody the right to, you have a right to counsel of your choice, but also have a right to defend yourself.
He's often had counsel, I mean.
Yes, always had.
Yeah.
But you also have the right to defend yourself.
Yeah.
And so that's a fundamental right. I mean, the court can't enforce you. Of course, the state has provisions to make for legal aid if either because of poverty or because of other circumstances, he can't access a lawyer. I remember when I was a defense counsel to Kensara Wiwa, when we pulled out from the case based on strategic reason, the state assigned him a lawyer. In fact, in many cases, the state may assign you a lawyer if you can. But in his own case, I think perhaps it's strategic. Two things, I think. This is also a political trial, even though it's based on a criminal charge. But the context, the landscape of this is politics, in terms of more than politics, agitation. This is like, IPOB is a revolutionary
band.
But what I'm saying, by nature of IPOB, it's a political organization attempting to challenge the Nigerian state based on some ideas. And so their leaders also consider their trial as political. Trial. Just like Mandela had, and then maybe Ken Saro-Wiwa. I remember the statement.
So Kanu is
maybe prisoner? He fancies himself that his own personal defense.
He's a political prisoner?
No, what I'm saying, he is facing a trial, but he is somebody who has been declared, whose has been declared illegal by the state. So there's a political dimension. Now, he might want to use this opportunity of this trial to put a country on trial. Let me tell you, when we wanted to defend Ken Saro-Wiwa, I remember very well when he came to the office with Ghana Family, he said that we shouldn't defend him. We have to convince him to go for trial. The idea was that the state wants to kill him, but he needs to put the good cause and put the state on trial strategically. So when we push the state to error, enough error, because it was clear the manifest intent was to hang Ken Saro-Wiwa, we pushed them to an error, we withdrew. By that time, the whole world, Bembom from Law Society and from Bar Council wrote a report that this is unfair trial. Don't forget that was why Nigeria was banned from Commonwealth and the Spiral event. So the point here is, maybe strategically, he fashions that he could say some things, use opportunity to as a revolution, as an agitator, to push a narrative he wants to push out. And he says, I don't mind if I die. I'm going to put the country on trial. dangerous gambit, if you ask, legally speaking, because Omolo is a very senior lawyer prosecuting. So you would require senior lawyers defend it, because the judge is going to base it on proving evidence.
Yeah, because I was going to ask you that. How should the courts, handle such a request and treat the defense of the accused person without legal representation? You've, used the political dimension to underscore what Kanu might be intending.
Exactly.
And it may too, as some analysts, had positioned that he probably doesn't want to go to prison.
Okay, two things can happen. First, the court has to be sure that that is his choice, okay? Two, the court also have to ensure that the court cannot lower the standard of proof or the standard of innocence for you because you have no lawyer. So the judge would act like a judge. You hear the case, look for evidence, and don't forget, in a Nigerian case, you have to prove the case beyond reasonable doubt against. So cannot even enter a defense, would still require the government to prove the case. The other point is that the court has to ensure that he gets the facility he needs for self-defense. So this is where it becomes tricky. You have to ensure, if you want to call witnesses to do pre-trial briefing, you have to allow those witnesses to meet with him. If, for example, so the fact that he's detained in DSS complicates the matter because of the way DSS runs their detention.
Yes, the lawyers have often complained about that,
exactly.
lack of access, to their
So the judge
clients
has to
in
ensure,
detention.
right now, the trial has to be fair and free. And the judge is the one who has to protect that freeness and fairness of trial. He has to do that by two ways. First, ensure that this accused person understands what he's going to do, that he has to defend himself. Two, provide him all the facilities. He's talking about case file. Assuming he wants to consult some books, assuming he wants to consult some of his witnesses, want to put them on the things that lawyers will do in their chamber. They bring the witnesses, hear their story, go through them, decide which witness is good enough. Kanu will now do it for himself. And so the restrictions of that DSS has to no longer work. And maybe this is where the judge might not say, you know what, I take authority and remand this person in prison custody. Where there's a structured way the prison allows for visits, provides for all those facilities. The DSS is not a prison facility. I think that is very clear. And that's why you see the lawyers complain they have no access. So the judge has a responsibility now and duty to ensure that this accused person, who is now his own defense attorney, so to say, has to be treated as someone who is preparing for a trial. When the lawyers are there, the guy could be put on chains and clamped away. The lawyers will be busy getting the job done. They go to court. But now that he's going to be his own lawyer, he needs the body presence, mental presence, he needs the liberty and the facility to prepare. So the judge is now under the spotlight. Whether he will afford this guy, I mean, the prosecution says 6 days. That doesn't really work. There's no way a known lawyer who has to go through this trial, get briefed by his former lawyers, get the files, will put up a defense in 6 months. That's going to happen. So we're going to see inevitably that the judge will bend backward, give him time, and also, more importantly, allow the DSS has to be under obligation now to allow him to meet with his witnesses, interview those witnesses, because that's what it means to defend yourself. And the law doesn't care whether you're a lawyer or not. You say, look, you must have fair trial, adequate facility to defend yourself, including resources, time, consultation. So this is a curveball of a sort. It complicates the procedure.
You can't, it's not time bound.
Well, the judge, it has to be a timeous prosecution, but the judge has to do a fair, okay? The judge will say, if
that's
this guy...
the scale of justice.
Yes, just say, okay, fine.
Must be balanced.
Can this guy get this thing done? If you don't give him the files, how can he do that? If you don't allow him to talk to his witnesses, how does he know who he's going to put on the witness box for himself?
And already, some of the witnesses that he's going to call are high-profile Nigerians and the rest.
I think if I was advising him strategically in terms of politics of this, I think it's going to be hot. If he decides to, some are compellable, some are voluntary witness. So if the court has to issue an order directing subpoenas to come to court and testify, of course, they will be, most of them are advanced, they are going to be advanced with it, but he probably wants to extract some confessions, some statements that his own thinking. I mean, this is dangerous, but politically, and that's the point here, many revolutionaries, you don't agree with them, so oftentimes consider their trial as the most important stage in their life to make their case. I recall we were doing Kensarawiwa. We tried a Waga, whether he will be jailed, whether he will be killed, and we use the case of Basanjo and Yaradua, Musa Yaradua. So we say, okay, if Yaradua will be pardoned, then he can't fancy himself, say, okay, I'll go to prison, but from there, the Ogoni cause will spread abroad. It didn't factor that it could be executed. So the notion is, I'll be jailed, but I'll be stronger in prison. The cost will be stronger in prison. So I don't know whether Nnamdi Kanu is this lucid and clear-minded now in prison. I don't know. But if somebody says, I want to defend myself because my guys cannot say what I want to say, then it means that they have crossed the threshold of fear, of conviction, and thinking more about the political outcome of that trial. That's really what it suggests.
All right. I mean, there are two sides to it. Anyway.
Absolutely.
Thanks so very much, Dr. Sam Amadi, Associate Professor of Law and Director, Abuja School of Social and Political